Okay, good afternoon, everyone, and welcome to panel 4. Great, more people. So my name is Tracey Epps, and apologies for anyone who's looking for James, who unfortunately couldn't make it. He's busy with some negotiations, apparently, so he was at the last minute unable to make it to Taipei. So I'm a trade lawyer and consultant based in New Zealand. And so I just got asked at the last minute yesterday if I would fill in to moderate. So this panel is entitled Breaking the Stalemate, Recent Approaches to WTO Rulemaking and Its Implications. So as we know, this conference has been held at a very pivotal moment in international trade and for the WTO. And the WTO, it's really interesting. We talk about it being in crisis, but I feel like we've been saying this for quite some time now. I remember about 3 or 4 years ago when the fisheries, subsidies negotiations were about to be concluded. And I saw this great headline saying, will the WTO save fish or will fish save the WTO? And I gave that to my students because I teach trade law as well. And I thought that's such a great question. But, it doesn't feel like either outcome was achieved. And we're still in that crisis moment. So when I was asked to moderate this panel, it was particularly interesting to me because in New Zealand, where I'm from, and where I think everyone in the trade policy world really does understand the importance of a rules-based system, it's becoming more and more common to hear comments along the lines that the WTO is not doing anything or the WTO is defunct. And the negotiation function is obviously a key part of that problem because it's really no longer seen as working effectively. But despite the difficulties, as we know, the WTO does remain a cornerstone of the global trading system. And so I think it's just such a timely panel to really look at not just lament about what's not working in terms of the negotiations, but to look at new ways of doing things. And so today's panel is going to explore 3 key trends that seem to be sort of shaping, or maybe shaping, I guess, the future of WTO decision-making. So the first one is the rise of plurilateral agreements, where we have groups of like-minded members sort of forging ahead with agreements among subsets of the WTO membership. Then we have the use of ministerial decisions to change the rules, with members relying on ministerial conferences and their decisions to adapt and update the rules. And so we're going to hear about that today. And then we have this other interesting development around the negotiation of rules on good regulatory practice, which also sort of feeds into the discussion, I guess, of how negotiations will develop and move forward. So we're going to hear from 3 panelists. So first we have Antoine Comont, who's going to start us off. And Antoine is conducting a joint PhD on plurilateralism at the World Trade Organization. Sorry, on plurilateralism at the World Trade Organization. He's not at the World Trade Organization. Antoine is affiliated with the research chair on the new challenges of economic globalization at Laval University in Quebec in Canada, and with the European and International Research Centre at the University of Bordeaux in France. And then we're going to hear from Sandeep, who is a lawyer with the government, Sandeep Chandy, isn't it? With the government legal department of the United Kingdom. And Sandeep holds an LLM from Georgetown Law School and an LLM from Jindal Global Law School in India. And then we're also going to hear from Federico Ortino, who I just realized I have no bio notes for. King's College London, is that right? King's College London. And I think also affiliated with Clifford Chance in London. So I'll let Federico provide any further introduction. So I think we're going to start with Antoine, who's going to talk to us about plurilateralism.
Thank you. Thank you, Tracey, for accepting to moderate this panel at the very last minute. And thank you also for your introduction. I'm going to talk about I'm going to talk about plurilateral initiatives at the WTO. And as you all know, over the past 2 decades, that do not generate binding legal obligations, such as the MPIA or the Trade and Peace Initiative during the COVID-19 pandemic. These instruments do not require consensus, are typically applied on a voluntary basis, and do not benefit from access to the dispute settlement system. While they offer flexibility and can serve as political platforms for regulatory convergence or transparency, their legal value is limited, and their institutional anchoring within the WTO remains fragile. In short, the legal architecture of the WTO does not preclude plurilateralism, but legality alone is not enough. To strengthen the legitimacy of plurilateral initiative within the WTO, 4 dimensions must be addressed: ensuring representativeness in negotiations, guaranteeing open and fair accession procedures, building inclusive implementation mechanisms, and integrating sustainability as a cross-cutting principle. First, concerning representativeness, many developing countries and LDCs struggle to participate meaningfully in plurilateral negotiations due to limited financial and human resources. To improve participation, 3 proposals should be considered. First, scheduling plurilateral meetings in a way that avoid conflicts with regular WTO sessions. Second, ensuring full transparency by making all working documents accessible to non-participating members. And third, involving the WTO Secretariat in the technical capacity to provide neutral analytical support. And these measures can reduce asymmetries in access to information and allow more members to participate or engage meaningfully in plurilateral processes. Second, openness is a fundamental requirement. While multilateral agreements in Annex 1A of the Marrakesh Agreement are by definition accessible to all, Annex 4 multilateral agreements have often operated as closed plans. Accession is subject to the approval of different parties, and latecomers are often asked to make increasingly costly concessions. To avoid a potential exclusivist dynamic, new plurilateral agreements should adopt objective accession criteria, particularly for market access commitments, and those that do not involve market access commitments should guarantee accession on an automatic basis. Third, inclusivity must be operationalized through technical assistance and capacity building. Structural constraints often prevent developing countries and LDCs from implementing new goals. The traditional WTO approach to special and differential treatment based on transition periods and vague flexibility is no longer sufficient. The special and differential treatment included in plurilateral initiatives must be modern and adapted to the realities of developing countries. Such as the IFD agreement, they must be based on the model introduced by the Agreement on Trade Facilitation, categorizing provisions and linking implementation of some to the benefit of technical assistance programs. Moreover, technical assistance and capacity building mechanisms must be monitored at the multilateral level to ensure equitable access to resources according to the specific needs of LDCs and developing countries. Finally, sustainability must be integrated into the design of plurilateral agreements. While some initiatives, such as the 42 strategy reform or the trade and sustainability structured discussions, place sustainability at the core, others, like the e-commerce initiative, remain silent on the environmental and social cost of digital trade. Taking into account sustainability may be a precondition for the public legitimacy and long-term viability of plurilateral initiatives. And to conclude, the rise of plurilateralism at the WTO is both a symptom and a response to the crisis of consensus-based lawmaking. While it offers pragmatic solutions in the short term, its long-term legitimacy depends on whether these initiatives reinforce or undermine the WTO's fundamental principles. The WTO may well be entering a new phase where multilateralism is preserved at institutional level, but differentiated legal commitments emerge through plurilateral pathways. Thank you very much.
Thank you, Antoine. Sorry, I should have said at the beginning that we'll invite each of the 3 speakers to make their presentations. And then I'll probably just take the chair's prerogative to ask 1 round of questions, and then we'll open it up. So we should have a really good length of time for questions, but we'll do that.
You can proceed.
We're good to go? Okay. Sorry, did we decide, was it Sandeep?
Thank you, Tracy. So I'm here in my personal capacity, and my views are not to be seen as those of the UK government. So if you open the WTO agreement, which is the framework of the institution, you'll see there are specific rules which regulates the adoption of any new rules, something like the fisheries agreement, or even to change or clarify the existing rules. You'll find these specific rules in Article 9.2 and Article 10, which is amendment, and Article 9.2 is authoritative interpretation. Even Article 9.3 is a waiver. Article 9.3 was used for the COVID vaccine waiver. Now, these rules regulate how to begin a multilateral negotiation round for fishery subsidies, or even how to adopt it, how to ratify it by the members. But there are these set of ministerial decisions. These are decisions taken at the ministerial conference of the WTO. You'll see that the ministerial decisions are adopted under a different set of rules, which is Article 4.1 and Article 9.1 of the WTO agreement. And most of these ministerial decisions are best endeavor trying to agree on changing the rules or coming up with a new set of rules. But you'll find a set of ministerial decisions which goes further than that. That is, it attempts, or it appears to attempt to change the rules by clarifying, or even in case of certain decisions, you would see that it's attempting to change the rules itself. To give you an example, is the Doha ministerial decision which tried to change the rules on subsidies, where developing countries which qualify for subsidies under Article 27 of the SEM agreement, the eligibility requirements for those countries and how they graduate from this exemption, all those rules were changed by the ministerial decision. And you've again got another Doha decision which clarified the TBT agreement and the SPS agreement. So the question is, these ministerial decisions do not adhere to the specific rules on changing the existing rules. They have been adopted under a different set of rules. So what is the legal character and status of these decisions? Are they binding? Are they enforceable? The answer is not clear. You would find that in disputes, WTO disputes, some of these decisions were considered. The Doha decision on which clarified the TBT agreement was considered by the panel in a couple of disputes. And what the panel did was, it couldn't formally take these rules into the dispute to settle the dispute, but they resorted to Article 31 of the VCLT and called it a subsequent agreement between members. The Doha decision on subsidies, it's not been subject to a dispute yet, but in two disputes, the US argued that India's graduation from Article 27 of the SPS agreement should be as per the Doha decision and not the SEM agreement. And it wasn't contested. Panels did not really go into what is the legal status of the Doha decision. Should we follow that, or should we follow what is actually given in the SEM agreement? So these are some questions which we've been exploring. I've got a co-author who couldn't make it. Yeah, Aditya, Laddha. So this is something which we've been exploring, and it's interesting to see that although most of the actual rules are negotiated as per Article 10 or Article 9 of the Marrakesh Agreement, but you've got these ministerial decisions which have been adopted in a different manner altogether. And there's no formal ratification required for these decisions, but they appear to be binding, and members appear to be respecting it and not breaching it. So what do you make of these decisions? Is that a different approach in certain situations which they want to adopt because the specific rules are not really fit for that particular purpose? No clear answers, but something which we've been exploring in the paper. Yes. Yeah.
Just for completeness, I'm a professor of international economic law at King's College London, and for a couple of years also the co-director of the newly established Center for International Governance and Dispute, nicknamed SIEL. Okay, so my topic is, the title of this working paper is on the turn to good regulatory practices in international economic law. And I guess the idea is trying to map some of the things happening and also understanding sort of some of the implications. So I focus more on the actual substance, not so much on procedure. And in fact, I thought of casting the web wide in the sense of course, I focus on a couple of existing examples within the WTO, but also I'm looking beyond a greater universe of agreements, and in fact, trying to capture some trading goods and services, but also investment. So there's basically these three different strategies that sort of fall within the same area. So this focus on improving the quality and efficiency of domestic regulation. Now, the first one is one that actually focuses on this term, good regulatory practices. It's basically sort of been developed over the last decades at least, particularly at the international level by the OECD, but also other regional intergovernmental organizations like the World Bank. Now, so good regulatory practices is basically sort of processes and tools to help improve quality and the effectiveness of regulatory measures. They often, although sort of the definition itself is quite narrow, but at the core of it, will have ex-ante impact assessments. Regulatory impact assessments, you hear that often. But also you have ex-post review of existing regulatory instruments. You have stakeholder engagement through public consultations and all sorts of other transparency requirement that sort of fits into that area. Now, the second strategy is a little bit narrower. It doesn't really focus on sort of general regulatory measure, but focuses on more specific regulatory processes. And here is where operators need to obtain authorizations, licenses. So there's a focus on trying to improve quality, transparency, and efficiency of those more specific processes. And thirdly, there's a focus on international regulatory cooperation. This is slightly different because it doesn't really tell countries how certain processes should take place, but in fact, it sort of focuses more on international intergovernmental cooperation, which may lead to further improvement of regulatory processes or framework. Now, I focus on the first one, on the regulatory practices. Now, the way I do it, so as I said, I started by looking at the reference paper in domestic relation services, the more recent WTO agreement on representation. But outside from those two WTO examples, I also look at recent free trade agreements. And you can sort of use whichever you want, starting from the TP, the comprehensive progressive the USMCA, but also more recently, Japan has also some interesting examples. Now, so that's the aim. Try to sort of understand a little bit. Now, let me say three areas. First of all, what's the thinking behind? What are the objectives of requiring this good regulatory practice? How regulation should be developed. Now, focusing on some of the recent FTAs, you can see that you can find sort of some specific underlying assumption that those FTAs make. Now, in a sense, how does regulatory adherence or regulatory practices promote trading investment? I mean, that's of course the underlying objective. Ultimate objective is to enhance trade investment. But how does posing or identifying these regulatory practices bring that about? Now, some of the FTAs I mentioned, they seem to be focusing on using these regulatory practices to reduce or eliminate unnecessarily burdensome, duplicative, or divergent regulatory requirements. That's the express language that we find, for example, in USMCA, but also identical in the Japan FTA. So there is a sense that tackling a certain type of problems facing traders, which we sort of know a lot about. Divergence of regulation or the unnecessary duplicative nature of domestic regulation. Now, if you look at the other two examples, the WTO example, the reference paper, service domestic regulation, and the investment facilitation for agreement, those remain much more vague. They don't really tell us how regulatory practices should bring about and with investment. Now, the reference paper identifies, sort of only emphasizes the difficulties that providers of services may encounter in satisfying certain domestic processes, particularly dealing with licenses, authorization requirements, where the investment facilitation agreement doesn't really say anything, doesn't identify the problem. And indirectly, it simply states that sort of this regulatory coherence discipline are there to enhance transparency, efficiency, and predictability. So one argues that maybe that's what is the ultimate objective, but it doesn't really identify the problem. It's one word. Reverse and think that the problem is the lack of such transparency and efficiency. But there is thus a bit of a sort of pondering what is the ultimate objective of sort of good regulatory practices. And to some extent, one can see maybe the FTA's trying to bring about sort of greater harmonization. It's one of the strategies. So see some of the Uruguay agreements with the WTO, and even facilitating mutual recognition by harmonizing some of the processes. You may facilitate also harmonization of the standards and potentially even find it easier for members to grant recognition. But I mean, I wonder whether there's also a sense that this may actually be sort of problematic. Some have argued that there's very little evidence at all that imposing good regulatory practices may actually bring about harmonization later. The evidence is this one. So that wish may sort of perhaps have been overstated. And in fact, the fact that the more recent WTO agreements, reference paper, Service Domestic Relation, the special agreement, don't do that, and focus more simply on bringing about greater transparency and effectiveness, may actually be a much more wise, realistic. Sorry, that was the first one. So the underlying assumption using regulatory practices. Now, the second issue is about scope. So potentially, I mean, the scope of all these various disciplines is quite broad. Now, in FTAs, usually the scope of the disciplines is on measures of general application relating to matters covered by the agreement, the FTA. So, pretty much anything, pretty goods, services, investment. Often these FTAs do include investment as well, to some extent. Now, there are limitations, of course. I quote one interesting one, just because we find ourselves in the situation where we are. The USMCA, for example, allows the three parties to identify certain regulation and certain regulatory authorities which are excluded from the overall regulatory agreement for this chapter. It's chapter 28. Now, the US has excluded one regulatory authority from the scope, which means the president. And this, well, no, USMCA was negotiated by our dearest US president. Now, when you go to reference paper on service domestic regulation, equally, although it's a little bit narrower, I think the preoccupation is there that stems from Article 6 of the GATS. The real preoccupation is service provider having to deal with satisfying procedures, licensing, qualification, procedures, and requirements. And so that is the focus of this in terms of scope. But at the same time, there are references there that also measures general application in relation to those licensing and qualification procedure requirements are also somewhat covered in there. The WTO investment facilitation, similarly, it's an interesting way to identify the scope. It's basically any measures adopted by a party relating to investment activities or investors of another. It defines investment activities to include establishment, acquisition, expansion, operation, management, maintenance, sales. Now, apparently, it's sort of specific in terms of scope, but in fact, partly because of the terminology used, it's measures relating or affecting. This is quite broad. And in fact, it may be difficult for anyone trying to identify those measures that fall in these various disciplines and those that do not. It's very likely that one occurs sort of in the sense of everything is covered, at least most of it. And this has actually been quite difficult specification in terms to identify at the current moment the level of limitations that need some developing countries in order to go into this agreement in implementing it. Actually, because the definition of the scope is specific, but at the same time potential. Now, last issue, and it's the nature of this obligation, which is quite peculiar and interesting. These are process-based obligations. They are, as I mentioned, they usually include transparency and public consultation, regulatory impact assessment, ex ante, interagency coordination. This is within a country, and then periodic review. This is the ex post review of existing regulation. These are the typical instruments or regulatory practices that you find in all of these agreements, with one exception, which is the reference paper on service development regulation, which in fact does not have regulatory impact assessment or interagency coordination. In that sense, less issues. Now, clearly, this process-based disciplines differ from sort of some of the better-known approaches that we know stemming from the WIRA. The second generation agreements, the SPS, they focus on necessity. These are clearly standards that apply to the way that those technical regulations or SPS measures have to comply with. Here, it's about the process, not the outcome, not the final result. There's an interesting provision in the Japan FTA which expressly says nothing in this section shall be construed as obliging the parties to achieve any particular regulatory outcome. So it's not about the actual outcome of regulation, it's about how we get there. Now, this process-based obligation do not usually include express references to trade and investment research. So this is where you really have to operate on your assumption. It's just you improve the quality of the way you regulate. And of course the scope is there, but in a sense, because of the breadth of the scope, as I just mentioned, you end up having to improve any type of regulatory processes, despite whether this has a clear impact on trade or investment. But it's more than that. Even when, for example, you refer to regulatory impact assessment, normally there is no reference, even when disciplines specify the type of consideration that one should adopt. You don't really have any specific and express references to trading impacts on foreign investment. Now, there's one exception to this, which is the Japan FTA, which actually says that carrying out regulatory impact assessment, there are several factors to take into account. For example, the very need for regulation, any feasible alternatives, the potential social, economic, environmental those alternatives, including on trade. That's the sort of exception that I found. Now, these are all considerations to be taken in the process of developing regulation. It doesn't have to be at the end you have to adopt this linguistic document. Now, this is interesting in part because some have also raised the question of the ability of and other trade investment commitments in trade agreements. And in fact, it's correct that the fact that you comply with the way the process is carried out doesn't mean that the end result complies with other existing obligations the state may have. Now, I'm going to stop here. Perhaps the last bit about this process-based application, which is quite interesting, perhaps to some extent it's disappointing, but it gives you the nature of these disciplines are. Most of them are not legal applied. They are usually casted in sort of best endeavor, members should consider or are encouraged to consider or encouraged to ensure. Now, again, there's an exception here. That's why I sort of use it. The Japan FDA does have the binding language shell for all the different types of regulatory processes that chapter 18 of that FTA has. Anyway, let's stop here. I spoke enough. And happy to sort of maybe discuss some of the greater implications, particularly also for the WTO, which is obviously started with. Thank you.
And I guess that's technical plurilateral agreements, as opposed to multilateral or regional. So I guess I'm just interested in whether you think that regional trade agreements, are a viable alternative, or why we would be pushing for plurilaterals as opposed to regionals, and what sort of roles like what's that?
Okay. Well, firstly, I think that regional trade agreements are not actually regional. So FTAs are no longer regional. I mean, when the UK joined this, when the EU is also planning to join it, when the EU is negotiating an FTA with Japan, US, Singapore, and others, these are not regional anymore. So actually, FTAs are creating a kind of trade preferences, let's say. And those preferences are discriminatory and exclusive by design. And it's not the case with plurilateral agreements that can be joined by every WTO members. Secondly, FTAs, and it's well known, fragmented the international legal order. I mean, if you want to address the new challenges of economic globalization, you have to implement WTO minus provisions inside LTAs. You have also to ensure or to enforce some LTAs provisions. And those issues raise another one, and is the consistency of LTAs with the WTO legal order. And it's not the case also with plurilateral agreements that are part of the WTO legal order. And thirdly, the last point is that we cannot forget that to address the new challenges of globalization. Some of them are global challenges, and we need the global answers to challenges, such as climate change or sustainability or food and energy insecurity. And we cannot address those challenges through regional agreements, but with plurilateral agreements, we can create a kind of best countries that can be joined after that by all the ones that join the club.
I've got some questions, but we'll leave that for the audience. Sandeep, can I just ask you, I guess I'm trying to also figure out, we've got these ministerial decisions, and then we've got the plurilaterals. Like, when do you think the ministerial decisions are more appropriate? What are the way that members would tend to go, as opposed to doing a plurilateral? Like, for example, we had the export subsidies Nairobi decision, which was a ministerial decision, right? But then we've had other, yeah, just wondering, like, if you could delineate the difference between the two.
Sure. So, the decisions which we have gone to, what we feel is that decisions are usually adopted when they want a temporary solution to a problem. Like the peace clause in the Bali decision. It was a temporary solution to a permanent, until a permanent solution was found. Or a minor clarification of the rules. It's not a means to substitute plurilaterals or multilateral tools, but just a stopgap or something minor clarifications. I guess why they've limited ministerial decision to such kind of limited is because there's a formal ratification process if you want to adopt a permanent set of rules under the Marrakesh Agreement and perhaps the domestic legal system of many members. So you wouldn't want to upset the formal process by taking this the route of the ministerial decisions. So it's not an alternative, but definitely seems to be an alternative for certain situations.
And Federico, I'm not entirely sure what my question is, but as you were talking, you mentioned that in CPTPP, in the regulatory coherence chapter, the rules are quite detailed. I think compared to like the reference papers on the disciplines, it's slightly different looking at the WTO reference papers. And so I just had me thinking, because I was involved in that chapter in TPP, legal advice to our negotiators. And it always seemed to me like it was a chapter that was very driven by passion of these regulators who were negotiating it. And it always felt a little bit different in that sense than some of the other more market access, traditional kind of liberalization chapters. You sort of really had these regulators who really believed in good regulatory process and what a difference that made. And so I guess, I don't know what the WTO reference paper negotiating process has been like. Has that been more of a traditional kind of liberalization kind of project? And so, yeah, I guess I was just interested in your reflections on that. And I don't know if there's any, I'm sure I'm not
I think you're really correct. The US has been really the driving force when it comes to trade agreements and the negotiation of regulatory agreements. Sometimes, chapters are called regulatory agreements, sometimes regulatory practices. There's a little bit of ambivalence. Now, interestingly, the reference paper on service domestic relations doesn't really, as I mentioned, doesn't really have the classic hallmarks of regulatory practice. It has a few, but not, for example, impact assessment. But so in that sense, I think it is correct. This is not about market access or trade liberalization or, in fact, investment market access. I think the idea is different. This is why sometimes understanding how that works, this is an alternative way to enhance trade and investment. And the more interesting example is the investment facilitation, the WTO agreement, because expressly says this isn't about market access. This is not about investment protection either. So clearly there's something different. Now, how different it is, this is why perhaps greater work should go into it. The fact that you specify the process, but not the outcome, may actually lead to nothing in terms of enhancing trade investment. But at the same time, I think the reasoning, the way you conduct the regulatory process, the way you open up to stakeholders, you start giving in different dynamics, who participates, who gets the information. Sometimes they're positive, but sometimes may not be so positive. You need to have the resources to be able to participate. There are some that do, some that don't. And so in the end, there may be even indirect impact given by the specification of a certain process, which may have, actually, this is sort of ambivalent because it may have market access effects, but also may have protectionism. So this is why there's really not a lot of work that has been carried out. That's why I would not want to continue looking at this and see, because studies have been carried out together with WTO, actually, the OECD on the reference paper. But actually trying to understand the actual dynamics of these new strategies, I think is useful, both in terms of helping, even so in terms of liberalizing, but also the opposite. Thank
you. Let's turn it over to the audience. If we take maybe 3 questions to begin with. But we've got a good half hour, so we should be able to take.
Thank you very much. I'm interested in the very lovely presentations. My question consists of 3 parts, and which all of which are going to Professor the first one, I'm very interested in your analysis of the recent trend focusing on the transparency of the footprint, and which are not directly related to trade and investment. I think it's it seems to me that they are related to optimization or rationalization of domestic economy rather than market acquisition. And I think that's first question is that response to their cognition. And the second question is on the investment related, maybe the labor issues or competition policy issues. I think that's, I'd like to know what you think about that. And the third question is then domestic policy rationalization is not directly related to market access. Means the domestic policy rationalization needs to be solved on the condition of trade liberalization rather than the path of the trade. Then it looks like the ITO charter. ITO charter, and my understanding is that ITO charter is basically the optimization of domestic economy, and then liberalize trade. I think your idea, it seems to me that your idea may go to the recovery or revival of the ITO charter. And I'd like to talk again to that. Thank you.
Meredith?
questions for Antoine. Super sympathetic to all of your arguments. So, substantial support for your vision. Four levels open, cases, such and such pledge. But as we know, there is, we have stalemate. What are your thoughts about how that stalemate could perhaps be broken? Aside from the workarounds, so there are workarounds. And just ban an investment in debts, and so on. So I'll give the challenge that I'm very.
Okay, one more. We'll take let's push on and see.
So I just had a quick question for Federico. So have you in kind of looking at the genesis of the services reference paper and the investment facilitation agreement? Of course, like the participants were exactly the same. So the US is part of services domestic regulation, but is not part of IPA. I was just wondering, what have you found in terms of the commonalities or the procedural obligations between those two? The other question on the IPA was, although you're right that it defines investment activity, it doesn't actually define what the investment is. Do you see that as a problem?
Thank you. So we have two questions for Federico and one for.
Okay. I'll start with you, Joy, so I remember. So I think, to be honest, the focus on regulatory coherence, which is used in the investment position agreement but not in the paper, is quite small. Probably there's more in the investment position agreement than in the reference paper. I think the great commonality, those two, is the streamlining sections. That's what I sort of think it's really the difficulties that the reference paper identifies, having to comply with the various notification procedures, licensing procedures. That's really the problem. And that is somewhat, in terms of, at least in terms of extent of, although investment position agreement is quite broad, it covers different areas, but that is a big part, streamlining piece of it. So, and they basically do the same thing, in terms of, accessibility of the various information, you can apply online, you can sort of, so it's a classic, I put it in within this bigger package because I do still see it, though it's not really the way you adopt a general regulatory framework, but it certainly is the way you actually apply to specific instances of that regulatory framework. So I think it's still part of that area. There's no decision on investment. They debated extensively whether to include it or not. So it's controversy, and in the end, they said, "Well, we don't actually include it," so they didn't do it. But I think you're left with the fact that even the reference to foreign investment is very rare. You understand that that is their concern, but in fact, in the definition, foreign. Yes, it does say activities of investors of other, but many other places don't really find it in. And in fact, in the end, this is the type of disciplines that you can discriminate on. Yes, maybe some countries have specific sort of processes deal with foreign investment flows, but often these are much more basic. How you get a license to open a shop, and that applies across the board. And so facilitating that helps not just the foreign investors, but it helps everybody internally. So that's why sometimes the scope is, despite the fact that it has some details, it's quite broad and it covers the everything. This goes back to your question, the labor law question. Unless they had defined sort of measures that directly relate or impact investment activities, maybe I could sort of start thinking that but they didn't. And so, to me, all those different regulations would affect the way that you manage and operate investment. At least, interpreted that. Get the last question. Oh yes, the ITO link. That's certainly an interesting idea that I need to pursue and see whether that's sort of come full circle, going back to the origin. But I think again, it is interesting to sort of track what is this push? What does this push come from? In investment, in the investment facilitation agreement, you can see it quite clearly. The really dissatisfaction with the traditional approach to promote foreign investment, which is by granting protection, by liberalizing, and by providing investors incentives. And the only way they could even talk about investment was to exclude those from the table. And maybe realizing that, in fact, one could pursue, because that's still the objective. The objective is still to promote foreign investment, people coming in or going out, whichever way. So that hasn't changed, but the strategy is different. Now I say, well, forget about those, protection, liberalization, yes. Let me try to sort of get to the nitty-gritty of trying to facilitate. Maybe I think to some extent the trade facilitation has also been, a relatively uncontroversial topic. Everybody agrees to improve trade in goods. And so the idea is, let's do something similar also with investment. And it's not surprising, in fact, that Brazil was one of the first that did not accept and never accepted classic approach to investment. Although it did sign a few agreements in the 90s, they never came into being. And so it's one of the few countries that actually does not have any traditional investment treaty. And they were the ones that sort of started thinking, well, how can we actually promote investment in a different way? And so I guess it's a combination of different elements that certainly has led to this situation.
Thank you for your question. We know that since the very beginning of the joint security initiative, so since the Bali Ministerial Conference, there is a strong opposition to some initiatives, especially by countries such as India or South Africa. The issue is, in my opinion, the issue is not a legal issue. It's merely a political acceptability and feasibility issue. And to ensure the feasibility of bilateral initiatives, we have to take care of their legitimacy, and we have to consider some of the proposals that I suggest. We have to do better when we are negotiating GSIs or bilateral initiatives. I mean, if we are looking at the joint initiative on e-commerce, some negotiators would say, well, it's a very bad deal, but we have a deal and we have to satisfy with it. Just because there is actually no agreement at the WTO on e-commerce, there is regulatory issues with e-commerce and especially with digital trade and digital services. So we are trying to have a kind of agreement on this issue. And the e-commerce agreement is the most that we have, but we have one agreement. But actually, if we are looking on development issues, those issues are not covered by the commerce agreement. There is many issues that were raised by developing and least developed countries, especially concerning capacity building, and also concerning technological transfer. And those issues were not covered and they are not discussed during the negotiations. So we have to do better. We have to take care of all issues that can be raised by the WTO members when they are negotiating plurilateral initiatives. And also, we cannot forget also that since 2001, we are wrong focused on development, on economic development. This is the way wrong. And actually, some countries like India are afraid that if developed countries obtain agreements on their own issues, such as e-commerce, they will not consent anymore to provide concession at the multilateral level on key issues for developing countries, such as agriculture. We have also to continue to negotiate at the multilateral level with all the WTO members, assure or to guarantee the feasibility of the initiative. Because if there is no evolution at the multilateral level, that will India or South Africa will continue to develop plurilateral initiative. And we can say, well, but we have an agreement on investment facilitation that is focused for developing countries. But on the same hand, there is issues concerning the fact that this agreement is maybe outside the scope of the WTO mandate. And we also have to deal with this issue. Because for countries also like India, because we all know that India are the main country that is proposed plurilateral initiatives. But India or Turkey have expressed some concern regarding the possibility that investment facilitation agreement fall under the WTO mandate, and it can be an open door if they accept or if they agree with the implementation or the incorporation of this agreement. It can be an open door to other agreements, maybe on labor rights, maybe on human rights, and they have since many decades some concerns about the possibility to bring such issues at the WTO. So we also have to accommodate with all those issues.
With the topic. And it goes back to something that you said as well. I mean, you know, the gap, the trading system has lived over decades without any form of movement, just by the willingness of members to participate. And decisions have been adopted apparently not following the rules. So I really would like to look, if you have a view on anybody, but what is the real reason why some countries really opposing, for example, of association agreement into next forward? I mean, the idea that you can bring to WTO other things that you don't want to, again, no one denies every member, you know, the consensus to actually accept. So they may be happy with this one, but not with another one. So they could discriminate. Is it a question about, you know, overload, focus on agriculture and sort of things? So I mean, you hear a lot of reasons, but I like to see whether
well, I think that India want to keep some political leverage on multilateral issues. You know, I don't know how to say that, but during the 13th Ministerial Conference, some WTO members arrived with the proposal agreement on IFD. And India said there is no consensus to discuss about this agreement during this Ministerial Conference. So we cannot discuss actually, maybe at the next one, or maybe at the General Council. The fact is that if there is an agreement on IFD, maybe India will have some other difficulties to obtain a waiver on the domestic support of the restock on agricultural products or food insecurity. So yes, this is the public stock holding, right? So maybe India will have other difficulties because they use, India used this agreement or the volunteer of some WTO members to incorporate it inside the WTO order and the possibility to do it to obtain a waiver on other issues. So it's a political deal. And that's why I've said that we have to continue to negotiate at the multilateral level to deliver outcomes at the multilateral level, want to ensure the feasibility of regulatory initiatives. It's very hard, I know that. I think it's the only issue we have actually to continue to deliver outcomes on trade issues at the broad level.
I do agree with them that some countries do feel that permitting plurilaterals would mean that some of their needs are ignored, sort of sidestepped by certain countries, and this will become the norm. Again, there issue that that's one. Second, again, what I felt is that, like you said, some of these joint statement initiatives, e-commerce or investment facilitation services, these are baseline tools. You could have it by yourself, you don't need rules set at the WTO. So, search for what is the best regulatory practice to use, everybody's benefiting. So the appetite for these sort of agreements, I don't know how much is there because you can reduce it. But I was reading something and it was said that why Uruguay round was successful was that even the industry really wanted it. While Doha round wasn't successful because there was no investment in it. So here, if you can do it yourself without the need for the tools, and your other issues being left out, what is
I heard someone talk about unpopulated discussions at the WTO on one of the plurilaterals, one country. There's a comment that we will just start applying. I'm just going to take another round. Actually, okay. Further questions? Caroline, check it. Caroline.
Thanks, everybody. Federico, I wanted to ask you to be maybe to check up with the end of the interview or original presentation. If you could get very quick time, we could ask you your views about the implications for the future of the WTO of the work on good legislative practices. Or not. So first of all, thank you so much for the very, very interesting presentations. I have some good questions for each one of you. I will start with Antoine. You mentioned several times the joint statement initiatives on investment, the plurilateral agreement of commerce, and you also indicated in our presentation that there is this obstacle of the consensus, positive consensus rule in order to formally admit these new plurilaterals into the WTO system. But you just mentioned the negative approach that some countries have, in particular India and South Africa. Do you see legal solutions to admit these plurilaterals in the WTO system? Are there any possibilities? What did you find in your research? What's going on in the debate in order to overcome these formally big obstacle, big rock of the positive consensus issue? And then for Federico, very interesting and challenging topic of research. Really, congratulations. I have two small questions. First of all, the scope of this international regulatory cooperation, because you put your finger in one very delicate issue. Because, I mean, regulatory cooperation, what do we need? Just the ISO standards? Or do we put it inside the supply chains, human rights, and environmental standards? So this is always concerns regulatory cooperation. So this is very interesting. And then the distinction that you make according to the wording that is used in some agreements by the European Union, of the European Union, and in others, Shell and so on and so forth. I wondered whether how these different wording, the choice of this different wording can be considered in light of the panel reports in the South Korea legal case. Because the panel reports, the group of experts said, okay, the language is not very strong, but there is a level of binding force of these process cooperatory provisions. So these could be relevant because the process can do a lot, no? Instead of arriving to this full harmonization. Let's try to constantly work together. Maybe we will take different roads at the end of our common path, but maybe we will have many points of contact, and at the end of the day, this is what we are. And then for you, Sandeep, I hope to remember correctly your name. There is all this debate, we have all these sources, formal, informal, no? Within the WTO system. The WTO system is in crisis. This is why my view is so relevant to extract a voice of plurilaterals. You mentioned that some decisions have been taken into consideration or asked to be taken into consideration during the litigation in the WTO system. What space do you see to use these sources to be considered to interpret the WTO provisions? And then another small hint for every one of you, in particular for Antoine. You were saying that India, South Africa, are saying that the plurilateral initiatives on investments are out of the mandate of the WTO because this would open the door, these agreements would open the door to human rights issues and so on and so forth. But I wonder if we apply what we have to apply, the principle of systemic integration, so the Vienna Convention is customary law, we have to apply each treaty provision in light of all the binding international rules. The rule is already open and has to be open. So it's just to clarify in a better way and to have clear ideas, no, what we have to do together and what we do together.
And we'll take one more question.
What's that?
Thank you so much. My question goes to Professor Federico Ortino. My question is about the appearance of corrective practices with a provision in FTAs. If we map all the FTAs containing such a package of corrective practices, most of them are signed by EU or US, one of the party. So I'm wondering whether you think that it is kind of a normative confusion led by EU or US, or we can find it in a more multilateral international setting. For example, WTO TBT committee also had discussion on collective practices, but I think the core of the scope of it are a little bit different. And related to that, as you say that the GRP collective practices is progressing towards a process-based obligation. That's considering the gap in the capacity of standard setting between different countries. How can we balance the regulatory autonomy with different countries of different capacity of standard setting? Thank you so much.
Okay, so I think I will begin. Thank you, Lisa, for your question. I will try to be short. Your last comment, Tracey, was concerning the IFD, we just have to implement it, whether or not we have a formal agreement. Yes, we can. But the issue is that we implement the IFD, we need institutional support. And that's why the WTO members are trying to incorporate this agreement inside the WTO order, just because to create a new WTO body to support the implementation of the IFD agreement. One of the issues is that we need, or the consensus is required to amend Annex 4, but it's not to amend Annex 1A that concerns multilateral agreement. And for those that were have a look on my presentation, it was questioned at a certain time of multilateral agreements implemented in Annex 1A. The last two multilateral agreements that we have, the agreement on trade facilitation and the forthcoming agreement on fishery subsidies, when we enter into force, we not enter into force between all the WTO members, only between the WTO members that are actually parties to the trade facilitation agreement or the forthcoming fishery subsidies agreement. And in this way, in this meaning, in this sense, they operate like plurilateral agreement. And the consensus is not required to add an agreement on the Annex 1A. But nobody wants to talk about the solution because we want to protect the consensus tradition at the WTO. It's not a question, there is no question to adopt a multilateral agreement without acting by consensus. So it is formally it is a possibility, but nobody wants to have recourse to it. And concerning your last question or your last remarks, the open doors. We can interpret the Marrakesh Agreement as the evolutionary interpretation of treaties with great articles of the Geneva Convention of the Law of Treaty. But on the same time, who is the authority to interpret the Marrakesh Agreement? Maybe the WTO statement body. And we already know that the adjudicators in the WTO are very reluctant to interpret quite extensively the WTO agreements. So I'm not sure that the WTO DSB will endorse this possibility. Not in many times, maybe in US streams.
The general exceptional clause
they recognize the value of the Geneva Convention of treaty to interpret in an evolutionary sense the WTO agreement, but they are very reluctant to do so. We can discuss about it later. I will let you know.
So, regarding space, I feel like for concluding these kind of decisions, there's definitely scope because the members, the parties are the masters of it. So if they choose to adopt decisions of this kind, the manner that they want, then they can do so with consensus. Right? Now, when it comes to enforcing, that is, bring these decisions before a dispute settlement panel, that is where the difficulty arises. Can you base your legal claim on the decision itself? That is, you say that a member's measures are in breach of something contained in a decision. I don't think so, because if you look at the DSU, dispute settlement, I understand only a couple of agreement can exist. But you can still use the decision depending on what is based in a dispute settlement. It's been done in closed secrets. The appellate body and the panel, I believe, that's a subsequent abuse and other dispute. There have been other disputes where, the question was whether a decision is Now, the thing is, the US has criticized this. During Trump 1.0, there was a USTR report on the complaints about the manner in which the panels and appellate body had considered these decisions was included in that report. criticize it. And if I remember the words correctly, said everybody is using these decisions and like in a form of stealth manner to create new rules or create binding rules. So when it comes to enforcement, I believe that because of the current scenario in which we are operating. But if parties want to negotiate these decisions, they can.
Yeah, briefly, I mean, I think that in fact many of the questions, at least I can answer quite sort of jointly, particularly, the implication for the WTO. I mean, you can take that question in many directions, but I'm going to take it in one. And I think it's also, as been mentioned already, which I think is the value of the WTO, the value of the organization that is there to implement and help members to implement existing rules. But it's probably when you come to good regulatory practices and having looked at the actual text that they've come up with, I think there's had to be a lot of work that we're going to developing those very broad languages. And there is part of the cooperation, which is already embedded in the existing instrument, is one that relies on exchange of practices among members. Because actually, the way you do it, the way you improve your regulatory process may depend on context, on type of regulation, and that has to be developed. There's very little that you find in the rules that tell you exactly how to do it. And so that is, to go back to also the question about sort of capacity. The WTO Investment Association Agreement does this, it's goal. The idea that you also have to help less developed countries, some developing countries, to be able to implement. It's not just capacity building, it's also financial assistance. That is embedded into it. Now, to go back to the question, well, you could do this unilaterally and bring it to the WTO, I am skeptical about that. I think that kind of joint process, developing those general principles into more specific disciplines, learning from practice, helping countries, members to actually do it, collecting finances, financial and technical support. I think you need, as you said, you need really institutional support, political support, which of course you can do it unilaterally. There may be regional institutions that can help with that. But I think you'd be much better if it happens at a multilateral institution. Now, this is just, this sort of eyes in the skies. Just given the current stalemate in the WTO and outside of it. I think it's important to remind us, maybe this is obvious, but for those who follow the WTO closely, importance of sort of the committee work, mentioned it to the TV, and really much has happened since the TPT agreement or the SPS agreement were adopted 30 years ago. And it has happened within those committees. Maybe not a lot, but certainly quite a bit. And the same should happen now with investor facilitation, for sure. Because that, as its own, is at best the first step.
Thank you. Well, we are just out of time. So thank you everyone for coming to this panel. And thank you very much to our three panelists. Thank you.
Yes.